I call the honourable member Claire Curran.
Thank you, Mr. Speaker. This bill aims to provide a window, and one would hope that it's a window to the future and not to the past. And unfortunately, there is some doubt as to whether that is the case. But I want to talk about what the future could be and should be, and where copyright does fit in. Mr. Speaker, this bill provides a provision. It provides a provision to adapt, for an industry to adapt, and I would argue that adaptation should be happening faster than it currently is at this point. But it is important that we allow our industries to adapt, because our film industry in New Zealand is critical to our own economy. But this bill isn't actually about our own our film industry and our economy. It's about ultimately about the film industries and other economies. The reason for this bill is to take account of that need to adapt and the need for it to have an expiry date until 2016, so that and to shorten that period where parallel imports are allowed to 5 months rather than 9 months, which we support. But we do say, and it's important to say this very firmly in this House, is that the world has moved on. And I just want to quickly bring the House up to date as to why this bill is necessary and why it's necessary that we move on as a parliament in considering copyright generally in our country. Before the widespread use of the digital exhibition technology, as it's called, the release of films in New Zealand was often delayed because of the limited availability of the cheaper second-hand film prints, and the distributors which waited to see whether films were successful in overseas markets before bringing them to New Zealand. So the ban was intended to give sufficient time for cinemas to screen films without the competition from DVDs, and therefore to increase cinema and distributor revenue. So increased revenue, of course, enabled distributors to reinvest more into bringing films to New Zealand, which provided consumers with greater access to a wide variety of films. As we know, the internet has changed all of that. So this ban was always intended to be a temporary measure. It was always going to be a temporary measure to allow the film industry to adapt. And the ban was introduced in 2003 for a period of 5 years to give cinemas enough time to transition to digital exhibition technology. And in 2008, that ban was extended for another 5 years, which we're now up to, because cinemas had not fully transitioned. Well, they still haven't transitioned, so they've been given another 3 years to do that, which, yes, is important. But a couple of things to note. First is that cinemas throughout the world and in New Zealand are not in decline, that the number of cinema businesses has risen from 66 in 2005 to 87 in 2012, suggesting that the industry has financial flexibility to invest in new cinemas. Digital technology has enabled cinemas to screen films closer to first market cinematic release dates. About a third of the films that are now released in New Zealand within 1 month of the first are now released in New Zealand within 1 month of the first market release date, and around 57% of cinemas have now converted to digital exhibition technology, and it's expected, as we should expect, that 100% will convert within the next 2 years. Now, Mr. Speaker, 2013, which is this year, was supposed to be the date that a copyright review was to have occurred in New Zealand. Labor supported there being a copyright review in New Zealand, and in fact, our policy supported it. Labor said that we would undertake a full review of the Copyright Act with the aim of introducing a new copyright bill within 18 months that updated and extended the framework for digital copyright in New Zealand. and that the first phase of that review would be to commission an independent analysis of the problems within the status quo from an eminent expert, such as the review done by the UK independent report Digital Opportunities, produced by Professor Ian Hargraves, which was created for the UK government, and then undertake a period of consultation. Mr. Speaker, that was a really important piece of work that was to be undertaken, and that hasn't occurred in New Zealand, despite the government actually saying they would go ahead with that. I'd be very interested to know from the Minister as to why that hasn't occurred, and I'm sure that we'll be trying to tease that out when we get to the Select Committee process. The US itself has actually undertaken a copyright review right now. But there has been a suggestion, and I want to put it on the record in this House, that the reason that copyright review, which was agreed to by this government, has been suspended is on account of New Zealand's ongoing negotiation of the Trans-Pacific Partnership Agreement. The United States has reportedly tabled terms during the TPP negotiations, which, if implemented, would require amendments to our current law. For example, there are some leaked texts which show that New Zealand has been asked to extend the duration of copyright by 20 to 70 years, depending on the type of work and the date that it was published. It has been suggested that this could also result in the expansion of the regulatory regime under which internet service providers must assist rights holders in enforcing copyright online, pulling New Zealand closer into line with the US Digital Millennium Copyright Act. We could also see a new criminal offence for the act of circumventing a technological protection measure or a digital lock, even in the absence of copyright infringement. Another proposal might require New Zealand to afford rights holders an exclusive right over temporary electronic copies, which could mean changing the provisions in our Copyright Act that carves out the liability for transient reproductions of copyright works as part of normal technological processes. Mr. Speaker, these issues are all extremely important. They relate to New Zealand's intellectual property laws, our regime, and also our intellectual property itself. We ask why that review is not occurring, why cannot we have a public conversation about these issues, and especially in the light of the US having just announced its own copyright review. I have said in this House many times, Mr. Speaker, that we have to get our head around the internet, that the language of copyright policies likens, in many regimes, including our own, likens a physical copy to a virtual one, which, if actually recognised in law, would become a problem for the internet service providers of all kinds. This is because internet traffic is transmitted from a point A to a point B by making temporary copies. Strictly applied, this right would pretty much make the internet illegal. And I think it's really important to have this public discussion in our country. And I would like to refer to some of the work that's been done by Internet New Zealand, who have recently said that we must take a principled approach on these issues, and if we must set down some principles upon which we are going to have this discussion. In the last year, Mr. Speaker, last October, I spent 3 weeks travelling through the United States on a trip devoted to intellectual property. And despite the reality of counterfeiting and fraud in the physical world, most of the discussion that I had in that period of time revolved around intellectual property in the digital environment. And I'd just like to say that the United States measures its intellectual property, Mr. Speaker. Its intellectual property it supports at least $40 million and contributes more than $5 trillion, or nearly 35% to the United States GDP. I ask why we don't measure it. We don't, because I've asked the Ministry whether we do, and we don't. We don't get the importance of our intellectual capital to our economic growth or either that or we remain in thrall to our trade partners. Our economic development, the growth of our weightless economy depends on this, and it's time that we grew up.
I call the honourable member Holly Walker.
It's kai hatu o te whare